I obviously am somewhat disappointed that the committee did not make criminal referral for a seditious conspiracy, but I still maintain that the committee did present information that is ample to support a charge of seditious conspiracy. And I will explain a little later why I believe the committee didn't make uh, the formal referral for um, seditious conspiracy, but did for incitement of insurrection and two statutes of fraud and what was the other one? I don't recall exactly. So it was four charges and conspiracy to defraud, insurrection. Uh, I think there were three conspiracy charges. Anyway, but the committee left a lot out. You know, the committee left out, as I said, the charge of seditious conspiracy, for which I believe there's ample information that the committee provided. It did not go at all into the lapses of law enforcement on January 6th and before uh, at the final hearing. They did touch up on it at the ninth hearing with what information they received about Secret Service. We also know that Secret Service destroyed messages from that day that are still not retrieved. They're not retrievable. So, and we learned about the tussle with Tony Ornato and Bobby Engel and that information from Cassidy Hutchinson. So they did touch on it, but they did not get to referrals for law enforcement agencies. And I believe the reason is the same as why they didn't make criminal referrals for seditious conspiracy. They did not talk about much about the witness intimidation and tampering, but for saying that there are instances of it, and they didn't raise that as formal referrals. But even at the last hearing, they mentioned about lawyers not disclosing to people who were being intimidated or tampered with where the money was coming from that paid the lawyers. So, but they didn't in the investigation or in their hearing. Or we'll learn more from the report when it comes out whether they will discuss these issues or not. And I would assume that they would, because they couldn't pack all of the information that they revealed to us in 9 hearings in an hour, like that the last hearing was. I believe the last hearing was mostly to summarize and then make the referrals. Uh, and here's why I believe that the four charges for which the committee made the formal referrals are conservative, and that there's still information from what they have gathered that the DOJ can use to pursue charges of seditious conspiracy and charges against members of law enforcement, and then follow the money and address the issues of witness intimidation. I believe that the charges for which the committee made the formal criminal referrals are charges for which the committee has information that they believe would pass the evidentiary muster, that would be admissible in a court of law and not be considered hearsay or not admissible in court because of prejudicial, that they're highly prejudicial for somebody. Now, or to Donald, and the probative value, the evidentiary value is low compared to the prejudicial impact of that information. So I believe that the four charges for which they filed the formal criminal referrals were charges for which they have presented information, and they will present information in their report that passes evidentiary standards, that would comply with federal rules of evidence and would be readily admissible in a court of law, meaning those charges are ripe to be taken and file. The DOJ can file indictments on it if they've already been doing their investigations. But according to the committee, these 4 charges, they have information that rises to the level of evidence admissible in a court of law to a fact-finding jury, which is critical in enforcing the rule of law, is following due process of law. Now, with seditious conspiracy, and with seditious conspiracy specifically, because that's the charge that I am honed in on, I believe that there is ample information that the committee has provided that can open doors for Jack Smith and his federal prosecutors and investigators to go out and seek evidence through grand jury subpoena and through voluntary testimony of people that would comply with federal rules of evidence and not be hearsay. And one specific example of that is what we heard from Hope Hicks, and then her text message, and then what the conversation that she had with Eric Hirschman, and then about what Hirschman told Donald Trump. All of that information, mostly at Hope Hicks's information, which is what we have under oath at this that we see, is hearsay, because it is she said, he said to him. It's not Eric Hirschman testifying in court that this is what he told Donald and this was Donald's reply. And that would rise to the level of that would, I'm not very good with federal rules of evidence. I mean, I got to be in that class, and I've not been in court in over a decade. But, whether what Hirschman says under oath or at trial and deposition as to his conversation with Donald Trump may be have evidentiary value and fall within the rules of evidence. But my point is that DOJ now has to parse through all of this information, all of these sources that to the layperson, to the American people, it's truth. It is Hope Hicks testifying under oath, under penalty of perjury, to Congress that this happened. I had this conversation with Hirschman, and Hirschman told me this, that he had this conversation with Donald Trump. But in a court of law, that is hearsay. That is he said, she said. It has to be proved that falls outside, that it's not hearsay and therefore can be admissible. And for that, the DOJ has to pursue Eric Hirschman's testimony, has to investigate if there are other people with whom Donald Trump had a similar conversation, and then corroborate one through the other, to the other, because you're never going to get Donald Trump to come to the stand and say, yes, I had this conversation. So, and that's what makes proving the charge of seditious conspiracy so difficult in the case of Donald Trump, because there has to be direct evidence of it. And at some point, if we find in a text message or something that the DOJ has uncovered, or a phone call or something from Mark Meadows' text messages and John Eastman's emails that rises to the level of direct evidence, then the DOJ, I bet my bottom dollar, will pursue the charge of seditious conspiracy. But I want you to be aware that the Secret Service deleted messages from that day. God knows how much evidence Donald Trump has destroyed and flushed down the toilet. And that's not even a joke. He actually did that. There are pictures of that. And the fact that he has been given 2 years to cover his tracks, he may not be able to, but that burden lies with the FBI and the DOJ, not with the January 6th committee with their limited budget and limited time. And at every step that this investigative process has gone on, both with the DOJ and with the January 6th committee, Donald Trump has thrown up obstruction after obstruction after obstruction. He hasn't really said, yes, I'm going to comply with the rule of law. He has said, I have a reckless disregard for the rule of law. So I'm going to do everything to the point of being sanctioned for frivolous lawsuits to get in the way of the DOJ investigating me and pursuing me and delivering justice to me. That's clear. But the committee has been conservative in not addressing the issues over which they have information, but not evidence that rises to the level of complying with federal rules of evidence. But mind you, this information will lead to evidence that the FBI and the DOJ now have the leads to, because of the January 6th committee's work, to pursue. It's much easier now for the DOJ and Jack Smith to pursue these people because the leads are provided, because many people have testified under oath that they spoke to these other people. So if Hope Hicks is lying, today Hope Hicks would be liable for penalty under perjury. So now it's up to the DOJ to rely on that information and go to Eric Hirschman and to any other people who they find to have the similar conversations with Donald Trump about what was going on. And this distinction, I believe, is the reason why the committee has been conservative about it. And this limited scope through which the final report will come out through, I believe, will help the committee's work not be seen as political. Because if they call it political, both the committee experts and the DOJ can point to say that the charges for which the committee made these referrals can be proven in a court of law based on the information that the committee has gathered, because that information rises to the level of being evidence that could be admitted into a court of law. They have been conservative and stepped back from going more into topics that fall completely peripheral to the central idea of what happened on January 6th and who was responsible for it. That's the core mission of this committee. And they complied with that core mission here.